Mr. Noel, you ready?
We are, Your Honor.
Is this Ms. Rogers?
It is.
All right, Ms. Rogers, good afternoon. How are you?
Okay.
All right, make sure you speak up loudly and clearly for me, okay? Very important that I hear you and that my court reporter hears you so we can take down everything you say, okay?
Yes, sir.
All right, Ms. Rogers, if you'll raise your right hand. Ms. Rogers, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. And Mr. Noel, y'all may need to move closer because I'm having a real hard time hearing her, and I doubt my court reporter will be able to hear her. Perfect, thank you. All right, Ms. Rogers, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knowles, or Kurt Knoll. There's no S on there. Sorry about that, Kurt. Kurt Knoll, are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Where you signed in the documents, is that your true and correct signature?
Yes, sir.
Mr. Knoll, do you believe Ms. Rogers to be competent today?
I do, Your Honor.
Have you explained to her her legal rights?
I have.
And I see here that the proposed plea agreement is that she's going to plead guilty to a first degree manufactured delivery of a controlled substance in exchange for the state's recommendation of a conviction, 8 years TDC J, with that being suspended for 5 years, $4,000 fine, restitution fine, court costs, reimbursements, and dismissing a prohibited substance in the correctional facility. Does that sound right, Mr. Knoll?
It is, Your Honor.
All right, Ms. Rogers, you are charged with manufacture or delivery of a controlled substance of penalty group 1 greater than or equal to 4 grams, but less than 200 grams. The range of punishment for that offense is confinement in the Texas Department of Criminal Justice for a period of not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000. If the court approves this plea agreement today, the maximum sentence that you could receive in this case would be 8 years TDCJ, which would fall within that legal range of punishment. Understanding the plea agreement and the range of punishment for a first-degree felony, Ms. Rogers, do you want to go forward with this plea?
Yes, sir.
Ms. Rogers, how do you plead to that offense?
Guilty.
Ms. Rogers, are you pleading guilty because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Knoll, any objection to state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense, Mr. Knoll?
No, Your Honor.
All right, court's going to review the evidence briefly. All right, based on the court's review of the evidence, I do find that there is sufficient evidence to convict Ms. Rogers of this offense. The court will follow the plea agreement and the recommendation of the state. Court hereby convicts Brianna Christine Rogers of manufacture, delivery of a controlled substance of penalty group 1 greater than or equal to 4 grams, but less than 200 grams. Court assesses her punishment at 8 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence, places her on community supervision for a period of 5 years, orders her to pay a $4,000 fine, $180 restitution, $290 court cost, and $785 reimbursements. Court dismisses under section 1245 cause number DA 2021-1040, prohibited substance or item in a correctional facility. Ms. Rogers, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. Good luck to you. I'm gonna have you step over with the bailiff to be fingerprinted, and then you'll talk to the probation officer for more information.
Gurley? You can get busy. You will speak to.
All right, Mr. Adams, who do you have with you?
Your Honor, this is Mr. Jeffrey Lance Gurley. We're set for arraignment today, I believe. And for the court's information, I have not yet seen a copy of the indictment in the case.
All right, stand by.
You have a copy of the indictment? That's a copy.
All right, Mr. Adams, have you had enough time to review the indictment with your client?
Yes, Your Honor. On behalf of Mr. Gurley, Mr. Gurley has a copy of the indictment. We just took a look at it together. He would like me to advise the court that his name is not properly spelled in the indictment. Specifically, his first name is spelled Jeffferey. Mr. Gurley advises me that his first name is in fact spelled Jeffrey. Otherwise, he is the same Jeff Gurley here in this hearing today that is named in the indictment. He understands the nature of the allegation made against him in the indictment. To that allegation, we did a formal plea of not guilty at this time. We waived the formal reading of the indictment and asked the court to set us for a pretrial hearing.
All right, the court will enter the defendant's plea of not guilty into the record. Court will set Mr. Gurley for pretrial in February. Court will set Mr. Gurley for February 8th. And that'll be at 1:30 if Mr. Gurley is in jail. It'll be at 9 a.m. if he makes bail in this case. And Mr. Adams, Mr. Gurley will need to speak with the pretrial release officer or the probation department there. There's going to be conditions of pretrial release that he'll need to sign. That way, if he makes bail, he'll have those signed. Right. Mr. Adams, do you have anyone else? I'm just going to ask y'all to step aside if y'all want to consult, so I can go ahead and keep the inmates moving.
Yes.
Who is this? And who do you have with you, Mr. Adams?
All right, this is Mr. Bradley Smith. We are set for arraignment here today, and as in the previous case, Your Honor, I have not seen a copy of the indictment yet.
Yes, I
Do you have access to it in discovery?
No, sir,
Okay, state hasn't made discovery available to you.
not yet. Not as of yesterday afternoon. Okay, I have a copy of the indictment here, Your Honor. Mr. Smith, you can spell your name correctly?
Yes.
You understand what it is?
Yes.
For the record, CR 21-392, State versus Bradley Smith.
Okay. I'm ready to proceed on the record when you are, Your Honor.
Go ahead, sir.
Okay. On behalf of Mr. Smith, Your Honor, Mr. Smith and I have reviewed a copy of the indictment in this case together. He advises me that his name is properly set forth and spelled in the indictment. He understands the allegation made against him in the indictment. We waive the formal reading of the indictment, enter a plea of not guilty, and request the court set us for a pretrial hearing.
All right, court will enter Mr. Smith's plea of not guilty into the record. Court sets pretrial February 8th at 1:30. If in jail, 9 a.m. if he makes bail.
Thank you very much.
You're welcome, sir.
Your Honor, I have with me here is Adam Joslyn. We're ready to proceed when you are.
Thanks, sir. CR 21-329, set for pretrial. Any contested pretrial motions, Mr. Adams?
No, Your Honor, but I do not. I have filed my standard pretrial motions, none of which have to be addressed here today. As of yesterday afternoon, I did not have a discovery in this file, and so I'm going to need to look at that to know whether or not I may have to file something like a 38071 motion or something like that.
Otherwise, you have all the discovery.
I don't have any.
Oh, you don't have any discovery.
Correct.
So you're really not in a position to say if you need to quash or suppress anything.
I don't know.
State, can you announce on that?
Judge, we had a different attorney of record listed for Mr. Joslyn, which is why Mr. Adams doesn't have the discovery. I will make sure that's taken care of immediately and sent to the portal to the proper attorney.
Thank you.
Who did y'all have?
Bill Stevens. And I'm not sure where that came from, Your Honor. That's just what our system says.
Yeah, Mr. Adams was appointed in October. So we had waiver of arraignment filed.
And Judge, we had a letter of representation from Mr. Stevens from September of 2021 scanned into the file.
We sent one out.
So that's gonna kind of create some delay in the case, so that everyone's aware. All right, court's gonna have to reset pretrial then, since there's no discovery. We have to reset it to February 8th. And Mr. Joslyn will need to sign his conditions of pretrial release before going back to his cell.
Your Honor, I've got Roger McCaslin here with me when the court's ready.
CR 21-362, State versus Roger DeLoss McCaslin, set for arraignment.
So on behalf of Mr. McCaslin, Mr. McCaslin and I have reviewed the indictment in this case together. He advises me that his name is properly spelled and set forth in the indictment. He understands the allegation contained in the indictment that is made against him. To that allegation, we're entering a plea of not guilty at this time. We waive the formal reading, and we'd ask for the court to set us for a pretrial hearing.
All right, court will enter Mr. McCaslin's plea of not guilty into the record. Court will set Mr. McCaslin for pretrial February 8th at 1:30 if he's in jail. Court will also order Mr. McCaslin to sign his conditions of pretrial release should he be released in this case.
And Your Honor, also do not yet have access to the discovery in Mr. McCaslin's case.
All right, State, if you can note Mr. Adams as counsel in your system and ensure that he gets access to the discovery. That's all, Mr. McCaslin. You'll need to sign your conditions of pretrial release. We'll see you on February 8th.
Yeah.
Mr. Adams, I apologize. I missed that.
It's okay. I'll have a seat.
You missing Mr. T?
Yes, Your Honor, I'll have a seat.
Sorry, Your Honor, that was my error. Mr. White?
All right. That's what I'm talking about.
Mr. Adams, Mr. White, I'm gonna let y'all do get out. I do have your client up here now, Mr. Adams, if you'd like to go in.
Mr. T. $50 on a bench. Even the butt. Yeah. Get a folding chair when it gets in. That's right. It's like an old metallic.
All right, court call CR 21-191, State versus Colin Gary T, except for pretrial.
Good afternoon, Your Honor. I do not have any contested pretrial at this time. I do have the discovery in the 00191 case. I have not reviewed it yet with Mr. Teague. I haven't had the time to do that. For that, I apologize. But I don't have any pretrial today. That's my short answer.
There being no pretrial motions, the court will set this for docket call on February 8th at 1:30, 9 a.m. if he makes bail.
Yes, sir. That was February 8th.
Yes, sir. Mr. White, are you ready?
Yes, sir.
All right, come on up with, is it Ms. Griswold?
Griswold.
CR 1574, State versus Kelly Lynn Griswold. Hearing on motion to revoke. Go ahead, sir.
Your Honor, the state and I have come to an agreement. The state has agreed to file a motion to withdraw. We've asked the court to extend her probation for 3 years so she can get her financials right and possibly undergo some mental health counseling.
And Your Honor, the state's motion to withdraw should be at the jail with the rest of the paperwork. I'll be over to the courthouse to sign. That is our agreement. However, the reality is that Ms. Griswold's probation expired, I believe, in January of 2020. So even though we're extending her for 3 years, we're really only extending her for 2 more years past today's date, because a year of that has already been eaten up. I talked with probation and they thought that was the necessary time for her to be able to adequately catch up to her financial obligations. They were worried if we extended it for 2 years, which in effect would only be one additional year, that wouldn't be sufficient for her to catch up financially. And additionally, Your Honor, we are adding as a condition that we eat up all of her back time credit, which I don't have in front of me, but it should be on the conditions there, as well as requiring a mental health evaluation, psychological assessment within 90 days to see if the mental health caseload would perhaps make her more apt to be successful.
Your Honor, the time frame is 37 days that's being eaten up.
So did I hear correctly, Ms. Heisel, did you say that she's already expired? Her probation period's already expired?
Your Honor, I believe it had, but I believe that this was filed before it expired.
The state complied and filed the motion prior to the expiration, Your Honor.
Okay. All right, so you are seeking to extend her. And Mr. White, on behalf of your client, tell me why I should do that. Consider I'm looking at the state's motion and they've alleged, in addition to money, if it was just money, it'd be one thing, but they're alleging just failure to report beginning in February of 20. So it looked like she was reporting for a good significant number of years. But I guess tell me why this is going to be different.
You know, Your Honor, she had done very well. We had talked about her situation. She started suffering from some depression problems, and she just stopped reporting. And Ms. Heisel and I, in talking with my client, believe that if we address some of that, that she'll be able to get it serves everybody's purpose by, one, allowing her to get her financials obligations to the court met, and two, allows her to get some help with a problem that she had developed during the course of, like so many people did during COVID, with depression and some other things. Ms. Griswold's also got a couple of health issues that she's been dealing with. It sort of has exacerbated the situation some.
All right, Ms. Griswold, if you'll raise your right hand. Ms. Griswold, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. And so you put your hand down. So you heard me ask Mr. White why I should put you back on probation, and you heard what he said. Is there anything else that you want to add?
No, sir.
So
I'm sorry.
you think that you're going to be able to comply with all of your conditions if I put you back on probation?
Absolutely, sir.
And you're asking the court to extend your probationary period. And you understand that when we extend, that means you're going to have additional costs. You're going to have to pay additional supervision fees and court costs and things of that nature.
Yes, sir. Yes, Your Honor.
Has anybody threatened, forced, or pressured you to make you feel like you needed to agree to an extension of your probationary period?
I'm sorry, I missed what you said. What'd you say?
I said, has anyone threatened, forced, or pressured you to make you feel like you've had to agree to the extension of your probationary period?
No, Your Honor.
All right, court will grant the state's motion to withdraw and will approve the agreement to extend the defendant's community supervision. All right, so you'll meet with the probation department. They'll give you more information. Thank you.
Thank you, Judge.
Is that all you have on today's jail docket, Mr. White?
Your Honor, I was retained late yesterday afternoon on Michelle Poynter, CR 13204.
All right, is Ms. Poynter there in the courtroom?
She is, Your Honor.
All right, Ms. Poynter, if you'll come up, please. This is CR 1324. All right, so the court will recognize Mr. Nolan White as counsel for Ms. Poynter. I'm assuming that there's no announcement other than you need more time and asking the court to reset the motion to revoke.
Yes, sir. I'm gonna need a little more time on this.
All right, this is what I'm gonna do. I'm gonna set it for the contested docket on February 24th. And if you and the state reach an agreement to resolve the case one way or the other prior to then you'll let me know and we can get it on a docket sooner than that.
I would anticipate, Your Honor, that I think we may be able to come to an agreement prior to that. So I'll let Ms. Abraham know when we do.
All right, thank you, Mr. White. So Ms. Poynter, if is this an MTR, no bond?
Yes, sir, it is.
Okay, all right, we'll see you back then on February 24th. Good afternoon, Mr. Manning.
Afternoon, Judge. We're ready on Miss Odom.
Right, this is cause numbers CR 2186, 187, State of Texas versus Courtney Michelle Odom. And are we entering a plea today, Mr. Manning?
Yes, Judge. If you like, I can recite the terms of the plea agreement.
Let's see, I may have a copy of it here.
There were some final corrections, Judge, that were made just a couple minutes ago, so there may be some additional corrections that aren't reflected in that original paperwork.
No, I don't see that I have any of those. So if you'll go ahead and recite the terms for me.
Yes, Judge. We're going to be proceeding under CR 20-00186. The cause number CR 2187 will be dismissed. We're proceeding under a lesser included kidnapping charge. That'll be a third-degree felony. Upon that plea of guilty, the state's agreed to recommend punishment be assessed at 6 years TDC and a fine of $2,000. There will be $290 court costs and $20 reimbursement fees.
Credit time?
There is 581 days credit time.
And the 187 case, you said dismissed, not 1245, just dismissed.
That's correct, Judge.
All right, Ms. Odom, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Make sure you speak up loudly and clearly for me so that we can hear everything you have to say, and so my court reporter can type down what you're saying, okay?
Yes, sir.
All right, thank you. All right, Ms. Odom, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
And where you have signed in the paperwork, is that your true and correct signature?
Yes, sir.
Mr. Manning, do you believe Ms. Odom to be competent today?
She is, Judge.
Have you explained all of her legal rights to her, and do you believe she understands them?
I have explained them and she does understand them.
All right, Ms. Odom, you heard Mr. Manning state what the plea agreement was to the lesser charge of kidnapping. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Yes, sir.
All right, Ms. Odom, the range of punishment for a third-degree felony offense is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. I find that the proposed plea bargain fits within that range of punishment. It has to be between 2 and 10, and I see here that the recommendation is 6. So, and also the $2,000 fine has to be less than 10,000. So I find that it would be a legal sentence. So understanding that that is the plea agreement and that's the range of punishment, do you still want to go forward with this plea today?
Yes, sir.
All right, Ms. Odom, how do you plead to kidnapping?
Guilty.
And Ms. Odom, are you pleading guilty to that charge because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor, there is a victim impact statement in this case that was forwarded to Ms. Taberham. We would ask the court to review that before, I mean, we've kind of already gotten there, but if you would review that before we proceed in accordance with the requirements for us.
How many pages do you believe there are of the victim impact statement?
That is a good question, Judge. Let me pull up.
The reason I ask is because I have a victim impact statement, and the second page, the bottom right says page 2 of 3. I don't see that I have 3 of 3.
Judge, I have page 2 of 3 as well as a tracking sheet, which I believe is what you are having as page 1. So let me really quickly, Judge, if you don't mind us taking a quick break on this, let me go ask Miss Cheney, who holds the original, how many pages are supposed to be included in that.
I'm going to go ahead and review the evidence before I do, as you're doing that. So, make use of my time. Other than the victim impact statement, and I'm going to wait for the state's final announcement on that. Mr. Manning, do you have any anything further on behalf of the defense?
No, Judge, defense rests on close.
And Judge, there was an additional page that I just forwarded to you by email.
All right, Ms. Heisel, the court has reviewed what I believe to be the complete victim impact statement. All right, can you give me a summary of the evidence to support the plea?
Yes, Your Honor, and I will give us all a disclaimer that this was Ms. Curry's case. She has worked it from the very beginning. So I will do my very best, and I'm sure Mr. Manning will correct me if I'm incorrect about any of it. Your Honor, Ms. Odom and her co-defendant took Willow Simmons, who was a minor. I believe she was 14. They took her from her parents' house. Willow has, I believe, both physical and mental disabilities. They took her first to the state of Louisiana, and then at some point, an Amber Alert was issued nationwide for Willow Simmons. Knowing that an Amber Alert was active for Miss Odom's vehicle, looking for Miss Simmons in that vehicle, they continued all the way to Kentucky, where her father resides, and they took Miss Simmons to her father's house. The FBI and several other agencies, both state and federal agencies, got involved to recover Miss Simmons safely, to bring her back to Van Zandt County. Miss Odom was arrested, I believe, in the state of Tennessee, in possession of a large amount of cash that had come from Willow Simmons's parents' house.
Thank you, Ms. Heisel. Any objection to that summation, Mr. Manning?
Overall, no, Judge. I believe the basic facts are correctly stated.
All right. Based on the evidence presented to the court will find that it does have sufficient evidence to convict Ms. Odom of the offense of kidnapping. The court will follow the plea agreement and the recommendation from the state of Texas. Court hereby convicts Courtney Michelle Odom of the third-degree felony offense of kidnapping, assesses her punishment at 6 years confinement in the Texas Department of Criminal Justice, orders her to pay a $2,000 fine, $290 court costs, $20 reimbursement fee. Court awards Ms. Odom 581 days credit towards her sentence for the time that she has spent in jail for this cause. Court also dismisses, pursuant to this plea agreement, cause number CR 20187, the smuggling of persons under 18 years of age. Ms. Odom, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over with my bailiff to be fingerprinted. Good luck to you.
Mr. Meyer, first three.
Mr. Weiner, if you want to move that back so that you're, yeah, there you go. Okay. There you go. You can move it back as far as you need to. I had to move it up because we had some soft-spoken ladies. So, all right, who do you have today? Mr. Furr, is he present in the courtroom?
Yes, I have Furr and then Ms. Jones as well, Judge.
All right, Jeffrey Daniel Furr, CR 278. All right, Mr. Furr is set for docket call today. Any announcements, Mr. Weiner?
Yes, Your Honor, we're still working towards resolution. I was retained on his older case, but he has not retained counsel on his newer charges. And so what I guess what I suggest to the court is that we have him go through the process of getting a court-appointed lawyer on the new case. That way we can resolve everything, hopefully all at once.
Let me look at this case. So I show that there's only one pending case. What's the other case that you're talking about?
I apologize, Judge. They're unindicted. There's an engaging and a couple of thefts. I don't remember exactly what all they are offhand, but it's 4 or 5 charges.
So I think what I'm gonna do is I'm just gonna, do you believe that you'll be able to reach an agreement on this charge without being able to take into consideration the other charges?
So the newer charges are a greater range of punishment than the one that I'm retained on. So that's my concern, that we wouldn't be able to get them considered, but I certainly would be glad if the state would be willing to do that. But that hasn't.
Yeah, I'm reluctant to reset this case where you're retained for him to ask for a court-appointed lawyer. I know Mr. Furs made bond numerous times on very high amounts. I'd be surprised if he met the indigent requirements for court-appointed counsel.
Well, and Judge, if you would like me to, I can visit with the state. If we can just reset my case and see if we can't resolve them all globally. You know, if they're willing to dismiss. I also don't want to be in a situation pleading a case I'm not hired on and haven't seen the discovery, that sort of thing.
Let's see. This is really your first docket call in this case. So can you got your calendar with you? Can you look in February?
Yes,
Tell
sir.
me if you're available the 8th or the 10th.
I am available on the 8th, Judge.
All right, let's do this. Let's set him for a docket call on February 8th. And I'll let you reach out to the state and see if y'all can come up with something. But if he wants court-appointed counsel, he's going to have to initiate that. We ask him, we send the forms over there, but we're not going to run him down and
Sure.
berate him until he fills it out. So if he wants it, he's going to have to fill it out, and then we'll review it.
Yeah, I'll explain it to my client, Judge.
All right. So February 8th at 1:30. You said you also have.
Cindy Jones, for some reason, I wasn't listed on the docket, but I've appeared on her case multiple times.
Make sure that we put your name in the system. All right, Ms. Jones, if you'll come forward, CR 13-368, CR 21-129. All right, I show that Ms. Jones is set for arraignment on the manufacturer delivery 4-2, which is the 129 case. And the other one is the motion to revoke. So have you seen the indictment in the 129 case?
Yes, Your Honor, may I proceed with arraignment?
Yes, sir, please.
I've been over the charging instrument. My client's name is spelled correctly. We understand the nature of the allegations alleged against her. Would waive formal reading and her plea of not guilty.
All right. Court will enter Ms. Jones's plea of not guilty into the record. We'll set Ms. Jones for pretrial and a hearing on the motion to revoke on February 8th at 1:30.
Judge, that's all I have. May I be excused?
Yes, thank you, Mr. Warner.
Yeah, Merry Christmas.
You as well. Mr. Sanders, you ready?
Yes, Your Honor, we're ready.
Justin Wayne Harrell, CR 21-263.
And Judge, with Mr. Harrell, I know we're set for docket call. I was going to ask if we could reset it one last time for one last docket call. In investigating the case, there's some information I gathered that's going to necessitate me to request some CPS records concerning the child alleged victim out of Henderson County, from what I've been told. And so I was asking for a little bit more time to do that, and in hopes that might help resolve the case.
February 8th, 10th, or 22nd?
February 8th would be great.
All right, court will set Mr. Harrell for another docket call on February 8th at 1:30.
And Mr. Sanders, if you find that you need assistance working with CPS, please let me know.
And that's what I was going to do, that it might be easier for the state to get those records. We have some, Your Honor, but it's pertaining directly to this case from Van Zant County. But it's my understanding there have been other CPS cases involving the child and her mother and other family members potentially unrelated to Mr. Harrell that I think that could impact this case.
And because we all know that those records are deemed confidential, if there's going to be a request for an in-camera review, I would like to have that as soon as I can prior to February 8th so that I can get those reviewed and make a ruling on whether any of those are going to be, withheld.
And Your Honor, the state would be making a motion for that. So I will get with our CPS attorney to see if she can't get us those records because the state would have concerns about confidentiality and relevancy if it's not the records pertaining specifically to this investigation.
All right, we'll see Mr. Harrell back on the 8th, and counsel will advise me if there's anything the court needs to do with regards to those records.
Thanks, Judge.
Do you have any other counsel in the jail that are ready? Mr. Stevens, you ready?
Yes, Your Honor. Your Honor, or Ms. Thompson.
Audrey Jean Thompson, CR 15506, CR 21193. All right, give me just 1 second. Let me pull up her news. All right, Ms. Thompson, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Audrey Jean Thompson, correct?
Yes, sir.
Ms. Thompson, you appeared before the court on September 27th, 2018. You pled guilty to the third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 gram and 4 grams. The court reviewed the evidence, found that there was enough evidence to convict you of the offense, and the court convicted you on that day, sentenced you to 5 years confinement in the Texas Department of Criminal Justice. The court also suspended the sentence that day and placed you on community supervision for 5 years and ordered you to pay a $2,000 fine. It was during your period of community supervision that the state filed a motion to revoke your community supervision. And in that motion, they alleged 1 count of a way that you violated the conditions of your community supervision. Have you had an opportunity to review that with your attorney, Mr. Bill Stevens?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And where you signed the paperwork, is that your true and correct signature?
Yes, sir.
Mr. Stevens, do you believe Ms. Thompson to be competent today?
Yes, sir, I do.
And does she waive the full reading of the state's motion to revoke?
Yes, Your Honor, will waive formal reading and enter a plea of true to all the allegations contained in the state's motion to revoke.
All right, Ms. Thompson, then at this time, I'm going to ask you, how do you plead to count one as contained in the state's motion to revoke? Does that count true or not true?
True.
And Ms. Thompson, are you telling me that that is true because in fact, the allegation is true?
Yes, sir.
Ms. Thompson, has anyone threatened, forced, or pressured you to plead true today?
No, sir.
All right, the court will accept the defendant's plea of true. Mr. Stevens, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted. The court takes judicial notice of Ms. Thompson's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
From the defense?
Rest and close, Your Honor.
All right, Ms. Thompson, based on your plea of true and the evidence submitted, the court finds that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement in your case. The court hereby revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. The court orders you to pay the balance of your financial obligations, including fine, court costs, and restitution. The court will take into consideration under section 1245, cause number CR 21193, burglary of a building, and DA 2021-126, theft of property. Ms. Thompson, the court awards you 448 days credit towards your sentence for the time that you have spent in jail on this cause. I'm gonna have you go over with the bailiff to be fingerprinted, and you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you.
Yes, sir. Thank you.
All right, is Trevor Rhoden in there?
Yes, sir.
All right, Mr. Rhoden. This is CR 21240. Mr. Rhoden is set for pretrial.
That is correct, Your Honor.
Any contested pretrial motions?
No, Your Honor.
All right, there being no contested motions, the court will set Mr. Rhoden for a docket call. Remind me of your schedule, Mr. Stevens. I'll set you.
Judge, I think you set me on the 6th or the 5th. Let me look real quick.
It's hard to keep up. I set you on February 8th for Ms. Kills.
That's right, Judge. I'm looking at the wrong month.
I can set you earlier, in January. We have a jail docket on 4th. I don't know how much time.
8th would be fine, Judge. February 8th. That's okay for the court.
All right. Court will then set Mr. Rhoden in for docket call on February 8th.
Your Honor, I'd also filed a motion to reduce his bond. I believe that might be on the docket also for today.
I don't have a copy, but State, do you have, did you receive a copy of the motion?
I'm looking right now, Judge.
Your Honor,
Yes, sir.
I think this may have already been heard because also in my notes, I filed this on November the 8th. And it appears that on November the 9th, we had a hearing. So I apologize. I think I just thought it was said again.
Okay. Yeah, I do show that I heard it on the 9th, denied the request and continued it at 20,000.
Yes, sir.
Okay. All right, then we'll see Mr. Rhoden back on February 8th. All right, do we have Andrew Madkin?
I do, Your Honor.
Right, now I do have your motion seeking bail reduction on that case. This is CR 21-3 and 4, say versus Andrew Casey Madkin, hearing on motion to revoke. Go ahead, Mr. Stevens.
Yes, Your Honor. This would be actually, I guess, our second setting on motion to revoke. The first one was just a few days. No, I was just disappointed. I apologize. But we did file a motion to try to get bond set, Your Honor. We'd like to be heard on that.
All right, go ahead.
Okay. I'd like to call my client.
All right, Mr. Madkin, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, let me put your hand down. You're going to have to speak up loudly and clearly. I know that Mr. Stevens is standing right next to you, and I know you may feel like you're yelling at him, but you need to speak up so that I can hear you and my court reporter can hear you, okay?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you, Judge. Please state your name for the record.
Andrew Casey Madkin.
Andrew, how long have you been in jail now?
150 days.
Okay. And you actually were brought in from Hunt County, is that correct?
That is correct.
Okay. And how long have you been in the Van Zandt County jail approximately?
Right at a month.
Okay. You're being held on two different motions to revoke your probation, is that correct?
Yes, sir.
Okay. One of them would be a DWI third and the other would be an escape charge, correct?
Yes, sir.
Neither case, as far as we know, have a bond set. Is that also correct?
Yes, sir.
Okay. Now, you are working, is that correct?
Yes, sir.
Okay. Who do you work for?
Donnie, Polly,
Okay. What's the relationship between you and your employer?
we're best friends.
And if a bond were to be set, would your employer help post that bond?
Yes, sir.
Where would you live?
I would live at his house.
Okay. And obviously, living with him, you'd be able to get to and from work.
That's correct.
Would you have transportation to get to and from the courthouse or other obligations?
Yes, sir.
Okay. And if the judge were to grant bonds in the amount of, say, $10,000 each, is that an amount that you believe your employer would be able to post on your behalf?
Probably 5,000 a piece, 10,000 overall. I could come up probably with $1,000.
That what you're asking the judge to do is set each one at $5,000?
Yes, sir.
Can you assure this court that you will make each and every court appearance?
I sure will. Yes, sir.
As a witness, Your Honor.
State.
State has no questions, Your Honor.
All right, Mr. Stevens, you want an argument?
Just briefly, Your Honor. He's gainfully employed. He's been in jail for quite some time. He has a job to go to. We're asking you to set bail in the amount of $5,000 each so he can go get out, go to work. His employer would be responsible for him to get to and from work and to and from the courthouse, Your Honor.
State.
Judge, state would oppose setting a bond. These are motions to revoke specifically on an escape while arrested or confined for a felony and a DWI. It appears as though Mr. Madkin has only been on probation for about 10 months before a motion was filed. State would oppose any setting of bond at this time.
I'm just looking over his case just one moment. All right, just going to deny the request to set bond on the motion to revoke cases. Court will set Mr. Madkin for the contested docket on January 27th. Do you have any scheduling issues that day, Mr. Stevens?
No, Your Honor.
All right, we'll set it for a contested hearing on the 27th. If we work something out, then we'll hear it that day. If not, then state will put on their evidence.
Thank you, Your Honor.
All right, you may be seated. We'll be adjourned in this case. We'll see you back on the 27th. All right, court calls CR 21-317, State of Texas versus Joseph Dan and Guada. Mr. Stevens, do you have a copy of the indictment for Mr. Guada?
I do not, Your Honor. Judge, I'm not going to go forward right now on arraignment with him. I need to visit with him more closely. I might be filing a motion for competency.
All right, we'll reset arraignment. Let's reset arraignment till February 8th. That should give you time if you need to file a motion to get it to
Yes,
me.
yes, sir, I will. Thank you, Your Honor.
Is that all you have today, Mr. Stevens?
Judge, I have Sonia Hip.
But I was told there was an agreement on that.
Mr. Stevens has not been read in yet. Yes, Judge. Sorry, Mr. Stevens. After reviewing the probable cause affidavits this morning, the state agreed to PR bonds on all of her charges.
Okay, I haven't, so I didn't see the email or anything.
No problem. I believe those have already been signed by judge.
Okay, great. Thank you.
So you
I
win.
guess that's it.
You won. You get to go home now.
Thank you, Judge. Have a Merry Christmas.
You too, Mr. Stevens. All right, Mr. Sminner, how are you, sir?
I'm fine, sir. How are you?
Doing great. Bo Allen Simmons, CR 21188. All right, Mr. Simmons, if you will raise your right hand, sir, I'm going to place you under oath. Mr. Simmons, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Bo Allen Simmons, is that right?
Yes, sir.
And Mr. Simmons, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Eric Sminner. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Where your signature appears in the paperwork, are you telling me that that is your true and correct signature?
Yes, sir.
Mr. Sminner, do you believe Mr. Simmons to be competent today?
Yes, sir, I do.
And have you explained to him his legal rights?
Yes, sir, I have.
Do you believe he understands them?
I do.
All right, Mr. Simmons, you are charged by indictment with a state jail felony offense of theft of property. Well, originally you were charged with aggravated robbery, but it looks like, and that's a first degree felony, but it looks like the plea agreement that the state's recommending is that you plead guilty to a theft of property less than $2,500 with 2 or more previous convictions.
Yes, Your Honor.
And it looks like the plea agreement is for you to receive 420 days in TDCJ,
Yes, Your Honor.
and that's the state jail. And you would have a $2,000 fine, $290 court cost, reimbursement fees, and you'd get 150 days credit towards your sentence. Is that your understanding of the plea?
Yes, sir.
All right, I have to tell you that the range of punishment for a state jail felony is confinement in the state jail for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. The plea agreement, as I see it, fits within that legal range of punishment. So at this time, Mr. Simmons, I would ask you, how do you plead to the state jail offense of theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Sminner, any objection to the state's evidence?
No, sir, no objection.
All right, state's evidence is admitted. The court takes judicial notice of Mr. Simmons' judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, sir, nothing.
I'm gonna read that. real quick. All right, the court has reviewed the evidence and I find that there is sufficient evidence to convict Mr. Simmons of this offense. Court will follow the plea agreement. Court convicts Bo Allen Simmons of theft of property less than $2,500 with 2 or more previous convictions. Court assesses his punishment at 420 days in the Texas Department of Criminal Justice State Jail Division. Orders him to pay a fine of $2,000, $290 court costs, $15 reimbursement fees. Court awards Mr. Simmons 150 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Simmons, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted. Good luck to you, sir.
Yes, sir, thank you. Maybe excuse your honor.
Yes, sir. Thank you, Mr. Spinner. Have a Merry Christmas.
Ms. Chester, you're up.
Hello, Ms. Chester. How are you?
Good, how are you, Judge?
I am doing. Let's see. You have a couple today. Who do you want to go on first? Simmons or Sherwood?
We're ready on both, whichever the court would prefer, Judge.
Erica Simmons, CR 1661. All right, Ms. Simmons is set on a motion to revoke. Any announcements?
Yes, Judge, this is her first MTR setting, and we're here and ready, but we're asking for a reset to that next MTR docket so we can continue negotiations with the state to try and see if we can work something out.
Okay. Court will set Ms. Simmons for the contested docket on January 27th. I can accept a plea that day. If no plea is reached, then the state will put on their evidence.
Perfect. What time for that, Judge? I'm sorry, I missed it.
It'll be in the afternoon.
Okay, thank you, Judge.
Yeah, those days are no different. We'll do bail in the morning and jail in the afternoons.
Perfect.
Brittany Sherwood, CR 21270.
Yes, Judge, this is the same set for an MTR. We received an offer from the state. We're still trying to see about negotiations and getting that explained to Ms. Sherwood. So we would ask to be set on that contested MTR docket as well.
All right, court will grant that request. We will set Ms. Sherwood for hearing on the 27th. If no agreement is reached, then the state will put on their evidence.
Thank you, Judge. That's all I have, Your Honor. May I be excused?
Yes, thank you, Ms. Chester.
Thank you.
All right, thank you.
All right, who are you ready on, Mr. Ashmore?
Judge, we're ready on Mr. Miller, Kareem Bernard Miller.
CR 1819, Kareem Bernard Miller. Hearing on the motion to revoke.
Judge, we've just been appointed on this matter recently. Ms. Heisel informed us this morning in the district court that the case really hadn't even been assigned to a district attorney yet. I'm just going to ask the court to reset this to the next available. I'm not even sure we need to contest it because I'm sure we'll be able to work it out. So if there's a way for that to happen, just even the next jail docket, so that way it can get assigned at the DA's office. We can get the information contained in the MTA and see if we can work out whatever there is to be resolved.
Next jail docket I have is January 4th.
I think I'm here, Judge. Yes, at this point, I'm already here, Judge.
Okay. All right, we'll set Mr. Miller's in for January 4th.
No, Judge, we're ready on Mr. Spriggs.
Casey Lynn Spriggs, CR 21371.
Judge, Mr. Spriggs and I have met this week already. As you're aware, the prior counsel I've been appointed in replacement, and I don't at this time have the discovery. Although that transfer is being worked on, I know the DA is working on it. We have filed, even in light of the Van Zandt standing order, I filed a motion for leave for some additional pretrial motions. There's going to be an amended motion for leave filed because it has a typo in it. Forgive me for that. There's a pretrial discovery motion and then a motion for funds for a court-appointed appellate counsel. The state hasn't had time to review and discuss yet. I think it'd probably be prudent in light of the nature of this offense and the gravity of this offense that we requested additional pretrial hearing to work with the state on those issues. I understand from Ms. Debbie Beasley that the verbal offer that was extended is a 40 TDC offer. I don't have that in writing yet either. So we're just asking the court for time to work through these issues with the state. Not a quick comeback on this one because there are quite a few things, witness issues, forensic issues, et cetera. So if we can come back on maybe even a February setting to give us that additional time to see if we can resolve these things without a hearing.
Judge, I show this is set for arraignment, but in any case, state would not be opposed to a reset to a time that would be convenient to Mr. Ashmore to do these things that he needs to do for Mr. Spriggs.
Well, let's address before we address any of those things, and even before we go through with arraignment, let's address the motion for competency examination and the report that was produced. Is there any objection to the report finding Mr. Spriggs competent to stand trial?
None from the state, Your Honor.
Sorry, I didn't mean to interrupt you, Mr. Woodway. Judge, I have reviewed that. I do not have a written objection on file at this time. I haven't had a lot of time to digest it. Before I can make any sort of objection to it or not, I believe that I'm going to need the medical records and, more importantly, the psychological records that were reviewed that are in part the basis of that report. Because as I understand it from Ms. Beasley, Mr. Spriggs was involuntarily committed
days before and days after this alleged offense. I just need to see those records before I could take a position on that fitness and the findings in there. We may not object to it, but I'd like to have an opportunity to investigate further. I have also told Mr. Spriggs about those findings, so we've at least had that conversation.
Do you believe, Mr. Ashmore, that Mr. Spriggs is incompetent to stand trial at this point? Just based on your personal dealings with him, that he doesn't understand the proceedings against him, that he can't differentiate between prosecution, court, and defense, and he can't assist you in forming a defense? I'm asking for just purposes of arraignment, because I can't arraign him if you're going to contest the competency finding.
For the purposes of arraignment, I think we can move forward. Whether that finding is subject to a collateral or a direct attack later. Again, I'd like the opportunity to really dig into what was actually investigated to make those findings and review those medical records that are the basis of that report, or at least in part are bullet pointed out as part of the bases for that report.
All right, so what I'm gonna do, I'm gonna reset arraignment, and we're gonna set pretrial on the same date. We're gonna
Okay.
set up February 22nd. Do you have a problem with that date?
No, I think, Your Honor, I'm already here, so that's much appreciated.
So I'm either going to expect that on the 22nd, we're gonna arraign him, and we're also gonna hear the pretrial matters, or there's going to be something filed between now and then objecting to the finding of the competency hearing or the competency finding, and then we'll have to, bring the doctor in and have a hearing on that.
Right.
Now, with what you're wanting for the medical records, and I'm assuming you're going to get those through your client, correct?
Either through the client or direct from the provider or from the doctor, who my understanding from his report, he would have them. His report references them.
But I don't know how he would have them. He may have you probably want to talk to him, but I don't know that there's nothing was provided to him unless the state provided it to him. I mean, he doesn't have the power of subpoena, and unless your client executed some kind of HIPAA release, I don't know how he would have access to those things unless it was just reported by the family or provided by the family.
Yeah, part of our concern there is that are exactly what the court articulated. And of course, as we understand it, the family are either material witnesses or unindicted co-defendants or both. So we're going to have to get that information independently or from the doc. So we appreciate the time to do that.
All right, so we're going to reset it for arraignment and pretrial same day, February 22nd at 1:30.
Thank you, Judge. May Mr. Spriggs be excused, Judge?
Yes.
Okay. Yes.
Who else do you have that's ready? Mr. Elmore?
Mr. Elmore.
All right, this is cause number CR 21355, State versus Jerry Ray Elmore. Show that this is set on a motion to set bail. I also have defendant's request to terminate court-appointed attorney. So I'll just tell you, we're only going to hear one of those today. So which one are we going to hear today, Mr. Elmore?
Judge wants to know which one you want to hear, sir. You've got a motion to challenge me as your attorney. I filed a motion to set bail. And judge wants to know what you want to go
Motion
for.
to set bail.
Okay, Judge.
All right, State, do you have a copy of that motion?
I believe we do, Your Honor.
All right, Mr. Ashmore, do you want to call your client?
Yes, if I'm got an email here I'm digging for. Apologies, Judge. Judge, just a brief open if the court will permit. Mr. Elmore, and I got to accept some responsibility. Mr. Elmore was arrested in the summer and the 90 days went by. We didn't timely file that. We filed it 15, 20 days late. I can't remember exactly what it was, but we were late on that. We did reach out to his family. We understand that the bail is $500,000, which is significant for a burglary of a building charge. Even with enhancements, it's an extremely high charge. We've had conversations with his family that a $20,000 bond is something in reach, that he would have some financial ability to make that. And that's our respectful request today, that the bond be reduced to something that would allow him to get out. And that being said, I'll go ahead and call the witness, if that's all right, Your Honor.
Mr. Elmore, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Elmore, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, you may put your hand down. Make sure you speak up loudly and clearly. Go ahead, Mr. Ashmore.
All right, Mr. Elmore, you through your family have contacted our office in the month of November.
Yes,
And through your family, we discussed the significant amount of the bond, $500,000.
Yes.
And you had informed us that you could not come up with, you didn't have the financial resources to meet that burden.
that is correct.
Okay. What do you do for a living?
I'm on disability income.
Okay. And what is that per month?
It's less than $553 a month.
Okay.
That's all I make.
And what about any other additional income from any source?
That is all I make.
Okay. What are your living expenses total?
With me and my wife, we're both on Social Security. We both make the same amount. So it's less than $1,200.
What are you on disability for?
I've got degenerated disc in my back, which is bone to bone, and I've got a plastic hip and plates in my neck, and I'm totally disabled.
100% disability
Yes,
for
sir.
Social Security?
Yes, sir.
Okay.
That's correct.
And where do you and your wife live?
We live in Grand Saline,
Okay.
2344 of it.
Rent per month.
It's $1,000 a month.
So any other net resources coming to you? How do y'all eat?
We don't, I mean, we're making it day by day. And we're just screwed. That's the reason this happened.
Well, we're not going to get into that. What we're talking about is showing the court that you have the financial
Yes.
ability to meet this bond.
Yes, sir, I do have that in my savings.
In savings,
Yes, sir.
you can with those limited resources,
Yes, sir.
you could put together enough to post a bond if it was reduced to $20,000.
Yes, sir. That's correct.
Nothing further, Your Honor.
And I want the record to be clear. The bond amount in this case is $50,000, not $500,000.
I'm sorry, Judge. If I misread that.
Judge, the sheriff's, the publicly available system says 500,000. I've seen 50,000 as well. I believe it's 50,000. It appears it should be 50,000. State definitely agrees at minimum right now to set at 50,000. I believe that's what it should be at, not 500,000. We can continue from there. We should frame this conversation with, it should be, the state believes at maximum 50,000.
Well, then I think that's where the error came from, is when we pre-indictment looked at the information we had. It's what's available on the sheriff's website, and it has that typo. Understandable. And that being said, I don't think that a decline even from 20,000 to something more reasonable. You've heard the financial hardship. He and his wife are both disabled. Got a bad hip and a bad back. It doesn't sound like he's going to run far. He's plugged into the community. His wife lives in Grand Saline, just up the road. Our request would be that the court consider something below 20,000, because the 20,000 was based on the resources they had in light of coming down from 500 to 20. But if we're coming from 50, you've heard the financial hardships they're under. We'd ask the court to consider something more reasonable even than that.
State, do you have any questions for the defendant?
State has no questions for this defendant, Your Honor.
Trying to find the original warrant or that sets the 50. I see the conditions of pretrial release that I signed back in August that say 50. I'm trying to figure out where that came from.
Judge, I have a arrest warrant signed by Judge Winters that was signed the 12th day of July, 2021, and it says recommended bond of 50,000. It's just, again, that's a arrest warrant signed by Judge Winters. I don't have like a clerk's, like an actual copy of the warrant. If I can email this to Mr. Ashmore and yourself, but I show that the warrant is 50,000, the bond was set at 50,000. I don't have where the magistrate set it at 50,000, 500,000. I'm unaware.
All right, the court will find that the defendant's motion for bail reduction should be granted. The court will set bail in this matter, CR 21355, at $20,000 with conditions of pretrial release.
Thank you very much, Your Honor.
Signing the order, and I'll have that sent over to the jail at the conclusion of today's docket.
Thank you, Judge. Judge, we still have an arraignment on this matter. I was not aware, and I'm not entirely sure the state was, because of the busyness of the last several weeks. This case was actually indicted on October 29th.
Do you have a copy of the indictment with you there?
I have a copy of the indictment. Jerry, is that your name? Spelled correctly. Jerry Ray.
Yes, sir.
Okay, and then right here, Jerry Ray Elmore.
Yes, sir.
Okay, and you understand the allegations is still chainsaw?
Yes, sir.
Okay, you understand that there's this Dallas County case, right? It's back in 04.
Yes, sir.
You understand that there's the Smith County case back in 2013. Yes, sir. These allegations, you got all that?
Yes, sir.
Okay. Judge, Mr. Elmore has confirmed that his name is spelled correctly in the indictment, that he understands that the allegation is burglary of a building involving a steel chainsaw on July 12th, 2021. There's two paragraphs alleging an offense in 04 and in 2013. His name is spelled correctly throughout the indictment. He's authorized me to enter a plea of not guilty and negotiate with the state on this matter.
All right, court will enter Mr. Elmore's plea of not guilty into the record. Court will set this for pretrial hearing. We'll set that February 22nd. Mr. Elmore, I'm going to order you to sign your conditions of pretrial release before you go back to your cell. That way, if you make bail, you're going to have to report, drug test, do things of that nature. Violation of that will result in me finding your bail insufficient. Mr. Elmore, does the court need to address your request to terminate your court-appointed attorney? I can't hear you.
You gotta speak it up, Jerry.
Yes, sir.
Do you still want the court to entertain your request to have Mr. Ashmore removed from your case?
Yes, sir.
All right.
No, I'm sorry, Your Honor. I do want him for my lawyer.
Okay. All right. If that changes, you'll let me know.
Yes, sir.
All right. We'll see you on the 22nd. If you make bail in Mr. Elmore, if you make bail in this case, your hearing's at 9 a.m.
Right here. See that? Not
It'll be in the morning.
in jail, 1:30 p.m. Got that?
Yes, sir.
That's yours. You need to speak to this young lady.
Yes. Thank you, Your Honor.
You're welcome, sir.
Judge, I need just a moment. Excuse me.
You have any other counsel in the courtroom that's ready?
Good afternoon, Judge.
Good afternoon, sir.
I'm here on Josue Rodriguez.
All right, this is cause numbers CR 18-503, 504, State versus Josue Rodriguez. I showed that we are set on a motion to reduce bail.
Yes, Judge, we were set for pretrial and we filed a motion for a bond reduction on this matter.
All right, do you have any contested pretrial motions at this time?
We do not, Judge.
All right, let's go ahead and set him then for a docket call. Are you available on February 8th or 10th?
I did look, I am available on the 10th.
10th. All right, we'll set each case for docket call on February 10th. That'll be at 1:30 if he's in jail, 9 a.m. if he's on bail.
Yes,
State, did you receive a copy of Mr. Versace's motion to reduce bail?
Yes. Yes, Your Honor. And there are, Mr. Rodriguez was arrested on 3 charges. It's the same charge, but 3 different counts. We indicted 2 of the 3. One of them has been outright declined by our office, which I've provided to both the jail and Mr. Versace today because the jail does not show that. One of the charges, the one ending in cause number ending in 504, the state is agreeing to Mr. Versace's motion as to that charge. However, the state is not in agreement as to the charge ending in 503.
So what's the agreement? What's the agreement at 504?
Your Honor, I believe he's requesting a PR bond.
That is correct, Your Honor.
And is that on, what's the basis of the PR bond, that he was not indicted within 90 days?
No, Your Honor. The state spoke with, this was a family and there were multiple children in the family. State spoke with, sorry, Judge. State spoke with the alleged victims. The son, after discussing with him, we have decided not to pursue prosecution with regard to that cause number. So basically, we are agreeing to a PR in the interest until this is resolved.
What's the bail set?
I believe it's currently $50,000.
All right, Mr. Rodriguez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Go ahead, Mr. Versace.
All right, would you please state your name for the court?
Josué Rodriguez.
And Mr. Rodriguez, you understand the charges that have been laid against you in this matter, correct?
Yes.
You have attempted from day one to get the bond taken care of on this, correct?
Yes.
You do not have the resources at this time to come up with a bond for $50,000, correct?
No.
Do you have any assets at home?
No.
Do you have anything you could sell, mortgage, to come up with the money in this matter?
No.
Do you have any family or friends that would be able to come up with some money on this matter to help you bond out?
Some.
And speaking with your family, what would be a sum that they would be able to come up with?
Maybe 2,000.
So at this time, you believe if we are PR bonding on 504, then on the current charge, your family could afford somewhere between $10,000 and $20,000 on a bond, correct?
Yes.
That being 10% up to a bond.
Yes.
Do you plan on trying to get a job when you get out?
Yes.
What kind of work?
Forklift driver, depending. Going back to work with my friends.
Okay. You currently also have child support obligations, correct?
Yes.
And you plan on, if you get out, if you're able to make the bond, getting out, start paying on your child support again, correct?
Yes.
And after speaking with your family, you've also agreed that if they are able to help out with any way, shape, or form with the money, you would attempt to reimburse them to the best of your nature.
Yes.
Okay. And you have a little bit of money yourself, but you aren't able to get access to it at this time, correct?
Yes.
And how much was that?
2 checks of $500.
Okay, so you have 1,000 on the outside that you'd be able to put towards it, and you believe your family can put another 1,000 towards that, correct?
Yes.
I pass the witness.
State.
Your Honor, state has no questions for Mr. Rodriguez.
Mr. Versace, you brought up his child support obligations.
Yes, Your Honor.
Is he current on his child support obligations?
Oh, we met with the AG last week. We believe it will actually be brought current. He's only behind about $1,800 at this time. The mother in that matter has spoke with the AG. I believe they will be attempting to come to an agreement to zero out the arrearages, but he will continue to pay the future amounts.
So he's behind 1,800, and you think
Yes, Your Honor.
and you're saying she's going to forgive that, and then he's going to put his money towards getting out of jail.
Well, Judge, they just took $5,000, I believe, from taxes. They, $8,000 towards it. And we had the hearing last week, and that's what the mother is requesting the AG do at this time. This way, he's able to get out, continue to work, and continue to pay his future support and pay the state back for any medical support in this matter.
Okay.
He's been up, Your Honor, in the matter of the checks that he does have, the family has tried to cash them, has tried to go to banks. They've been unable to cash them. The banks refuse to cash them at this time.
State, any argument?
Your Honor, state has tried to help Mr. Rodriguez out by lifting 2 of the $50,000 bonds, remaining only one $50,000 bond. Given the offense alleged, we believe that is a necessary bond in order to protect both the victim in this case and the community. We would ask that no further bond reduction at this time be taken based on the seriousness of the offense.
Is there an alleged victim that is a family member or in the same household as Mr. Rodriguez, whereas if he was released, he would be back around this individual?
Your Honor, that's a semi-complicated question. They are not residing in the same household. However, Mr. Rodriguez has biological children that are the half sibling of the alleged victim in this cause. I do believe that there are procedures in place by the family to keep them separated. And we actually, Mr. Versace has with him today a protective order that I believe we were going to ask you to take up as well. that Mr. Rodriguez was going to go ahead and agree to today, which would provide protection for that named victim.
Mr. Versailles.
Sorry, what was that, Your Honor?
I'm sorry, the audio is bad today. Is there a protective order that your client's agreeing to today?
Yes, Your Honor, we are in possession of and have signed a protective order that would be in effect until January 1st, 2027.
Tell me how the January 1st, 2027 date is calculated.
Your Honor, it is based on the state's current offer for Mr. Rodriguez. The victim indicated to us that she does want additional protection, however, not necessarily lifetime protection. I did ask them to return a call to us yesterday that was not returned. The victim turns 18 in, excuse me, Judge, I'm trying to think. I believe it's April. It's either March or April. So we wanted past her 18th birthday because she does want additional protection. So the 5 years was based on the state's current offer for Mr. Rodriguez. It's our understanding he's not 100% on board with entering into a plea under that agreement at this time. But we believe 5 years is sufficient to get her into adulthood, allow her to establish her own household and make decisions for herself about whether she wants to have any interaction with Mr. Rodriguez, given that her siblings, he is the father of her siblings.
And Your Honor,
Yes, sir.
Your Honor, if I may, since this allegation was alleged, and CPS did briefly get involved, he's had no contact with his wife's children that are the basis of this case. There's been no contact in 3+ years at this time already.
Okay, and back on the protective order. So does this court have jurisdiction to grant a protective order that's 6 years in duration without there being a conviction in this case, or him already being convicted and then confined in jail or imprisoned? I'm not sure that I do.
So, Your Honor, that was, I spoke with Ms. Barker because we did file in this application and get a hearing date set today with the understanding that we would be proceeding with a plea, with the understanding that a conviction would come before the protective order. However, I spoke with Mr. Versailles via Mr. Rodriguez that they were willing to agree, but Your Honor,
We're not doing that.
right. Right. So that does, I didn't fully flush that out, Your Honor, because we were agreeing and not having a hearing.
So either I can take up FM 21-511, protective order issue, and he can agree to it today. And I think the maximum I would be able to give him is 2 years, since it's prior to any type of conviction, or we table the protective order and then he has conditions of pretrial release that grant the same protection as the protective order for the duration of the criminal case, and then we approach the protective order again later upon the disposition of the case for something longer.
Your Honor, given that I was unable to speak with our victim about this, I would feel more comfortable with the court just continuing the protective order hearing until such a time that a plea is entered, or we make a determination that we need a hearing separate from a plea on the protective order. And like I said, the state is sufficiently convinced that between the conditions of pretrial release and the safeguards that the family has taken, that our victim is safe. This is something she wants going forward. But I feel comfortable with us not entering the protective order today.
And you're right, about pretrial conditions as well. So he is aware that there would be possibly conditions of bond upon his release.
Let me look in there to see if we already have conditions. I'm confident we do. He may not be aware of them, but I'm sure that we do. No, I don't see conditions of pretrial release, so I will sign some and have those sent over to the jail. All right, so what I'm going to do is I'm going to find that $50,000 is excessive at this time. Court's going to lower the bail in this case to $25,000 with conditions of pretrial release for the alleged victims, for no communication whatsoever with the alleged victim in this case. And so I'm going to have that sent over to the jail, and Mr. Rodriguez must sign those prior to being released.
Yes, Your Honor.
All right, so I'll sign that order and the conditions, and I'll have that sent over after the docket concludes today.
Thank you, Judge.
We'll table FM 21-511, and we'll carry it along with this, any resulting plea in this case.
Yes, Your Honor.
All right, we'll see him back on February 10th. If he makes bail in this case, it's going to be at 9 a.m. in the morning, not 1:30. You'll have to
Yes,
report,
Your Honor.
you'll have to report to the courthouse.
All right, thank you.
Judge, may I approach?
Yes.
Just need to wrap up with Mr. Grubbs, Your Honor. We're just doing a reset. Judge, this is CR 20-00164. Was just assigned this case at about 1 o'clock. Mr. Grubbs is before the court on a motion to revoke or adjudicate. I don't believe the case has been assigned to a prosecutor. I don't have the motion at this time. I do have the motion, and I've reviewed it with Mr. Grubbs. Just ask the court for an opportunity to reset this for another jail docket so I can work out whatever agreements I can with the state, visit with Mr. Grubbs about them, about those agreements.
Next jail docket, as you're aware, is going to be January 4th. That's not very long. Do you want something later than that?
Yes, actually, that's probably better. Maybe even if I'm reluctant to set it on the contested because I don't think we'll need that, but that would certainly give us time to work out what we need to.
All right, we'll put it on the contested docket on January 27th.
And Mr. Ashmore, just for your records, this one will be mine.
Okay, thank you, Ms. Heisel. Judge, may I be excused?
Yes, thank you, Mr. Ashman.
Thank you. Merry Christmas, y'all.
Good, Your Honor.
Good afternoon, sir. How are you?
Well, you. We're here this afternoon, Judge, on a motion to revoke on Michael Sanders. This is a first setting. We're not ready to proceed on the motion, but I do have, on a motion to revoke, I do have a motion to set bail that I filed on November the 30th. And we'd ask that the court consider that motion this afternoon.
All right, the state's received a copy.
I did serve the state through an email to Ms. Adney on the 30th, Your Honor. I've been having trouble with the e-file system accepting my filings, and so I had to do it through emails, but I did send a copy of it to Ms. Adney.
All right, state, do you have a copy?
I'm looking, Your Honor. I have I believe a handwritten by the defendant motion for a bond reduction. I do not see a filed motion for a bond reduction. I have a motion by Mr. Green to substitute counsel, but I don't see.
They were both filed the same day.
That's fine, Judge. State would be prepared to proceed based on that.
All right, I'm going to play your time screen.
I wouldn't, Your Honor, I'd call Michael Sanders for the limited purposes of the request for bail to be set.
Mr. Sanders, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, make sure you put your hand down, make sure you speak up loudly and clearly. Go ahead, Mr. Green.
Thank you, Your Honor. You are Michael Sanders, is that correct?
Yes.
And Mr. Sanders, you are the defendant in this motion to revoke that has been filed by the state of Texas in the case in which you're on probation.
Yes, sir.
And you are here today asking Judge Martin to set up a bail for you so that you can be released from jail while this motion to revoke is pending a resolution.
Yes, sir.
And how long, you're currently in custody of the Van Zandt County Sheriff, is that right?
Yes.
How long has it been since you were arrested on this motion to revoke?
50 days, October the 28th of this year.
And that was an arrest that occurred in Montgomery County, is that right?
Yes, sir.
And that was an arrest that happened when you reported to your supervision officer down there as a condition of your probation in this case.
Yes, sir.
You have been reporting in Montgomery County, is that right?
Yes, sir.
And we were visiting before the hearing. You believe your probation has been transferred down there for about 2 years or a little over 2 years?
Yes, sir.
And you've lived in Montgomery County during that time.
Yes, sir.
And you believe you've been living at the address that you live at in Montgomery County for about 3 years.
Yes, sir.
You have a true statement that you have never failed to appear to court.
Yes, sir.
You have been reporting to your probation officer each month while you've been on probation in this case.
Yes, sir.
Never failed to report.
No, sir.
You have a job.
Yes, sir.
And where were you working before you were arrested?
GM Mechanical.
Say that again.
GM Mechanical.
And what kind of work do you do there?
We're a remodeling company.
And you believe that if you're released on bail, that you will continue to work there?
Yes, sir.
You will return to your home in Montgomery County.
Yes, sir.
And you're telling Judge Martin, that you will appear in court when you're required to appear in court.
Yes, sir.
And without talking about the facts of the cases, you had a federal criminal case that was a part or related to the case that is you're on state probation in this county, correct?
Yes, sir.
And in that federal case, you were ordered to serve a period of time in the Bureau of Prisons.
Yes, sir.
And as part of that sentence, you were allowed to self-report to the unit that you were going to be confined.
Yes, sir.
And you did that.
Yes, sir.
There was a time when, as a part of that federal case, you were sentenced or had your supervised release revoked.
Yes, sir.
And part of that sentence allowed you to self-report to serve the remainder of that sentence.
Yes, sir.
And that you have always felt or always reported for your supervised release.
Yes, sir.
And you've always reported for your probation.
Yes, sir.
And you're telling the court that you will appear for court in this matter when you're required to appear.
Yes, sir.
As far as a bail amount, is it a fair statement that you would ask the court to set a bail amount of $10,000?
Yes, sir.
And while you will not be able to post that amount, you have daughters that are able to help you with that.
Yes, sir.
I pass the witness, Your Honor.
State.
Mr. Simmons, I'm sorry, Mr. Sanders, are you aware that you are currently behind right close to $170,000 in your probation requirements?
No, sir.
You were assessed restitution of $165,000. Is that correct?
Yes, sir.
Appears that your delinquent amount right now, I'm sorry, is $71,765 is the amount that you are delinquent right now.
Yes, sir.
I'm not going to ask you specifically about your allegations, but do you as a person believe that spending money on a bond would be a better use of your money than paying off some of your delinquency?
Yes, sir. Yes, sir. I do.
I think Mr. Green asked you briefly about this. You're reporting in Montgomery County, is that correct?
Yes, sir.
Do you live in Montgomery County?
Yes, sir.
Okay. I have no further questions, Your Honor.
Just one, Your Honor. Mr. Sanders, it's your, we talked about if you're released on bond, that would allow you to make some payments towards your restitution while you were out on bond and pending the resolution of this case.
Yes, sir.
That's what you intend to do.
Yes, sir.
When you return back to work.
Yes, sir.
Pass the witness, Your Honor.
State, any further questions?
No, Your Honor.
Mr. Green, you want to argue?
Judge, we believe that the court should set a bond in this amount, in this case, an amount of $10,000 and would so request.
State.
State would oppose any bond being set on the motion to revoke, given the large financial burden owed. We believe that that would be better used to paying off some of these arrears. Also, given the number of alleged violations, we do not believe that setting bond would be in the interest of justice, Your Honor.
I think it's the right.
Judge, would you look at the chat on Zoom?
All right, so what I'm going to do is I'm going to not going to rule on this motion. I believe that I may have served as a prosecutor during the pendency of Mr. Sanders' case, but he was put on probation and or convicted during my term as criminal district attorney. And I may have some knowledge on it. I don't have back up say it this way. I'm not sure if I was or not, but I don't have access to the file to determine that. So state, I would ask you to do a due diligence check to see if perhaps I was, and report that back to the court and to Mr. Green. And if I do appear to be labeled as a prosecutor on that case anywhere, then I will voluntarily recuse myself. But I want to make sure his name does look familiar, but I don't have immediate recall of that. And so if Mr. Woodwike, you determine that I did have some kind of prosecutorial activity in the case, then you'll let me know, and I'll immediately do a voluntary recusal and ask my presiding judge to appoint another magistrate to preside over the case. Another judge.
Yes, Your Honor. I will make that report this afternoon or early tomorrow.
Okay. All right. So let's set Mr. Sanders then.
Judge, I was going to ask for the afternoon of January the 4th. I think this is something that if the state and I get together, we could potentially reach an agreement on. If not, then we could put it on a contested docket.
Okay. So in the interim, we'll go ahead and place Mr. Sanders on the January 4th docket, and state, you just do your due diligence search for me as is customary in these cases, and then just report to me, Mr. Green.
Yes, Your Honor, I will do so.
Thank you, Mr. Green.
And Judge, if it would be appropriate, if it's determined that you did not have any involvement in that case, will the court then rule on our request for bail? Once you become, if it's determined that you did not have any involvement on it?
Yes, sir.
Okay, thank you, Judge.
As soon as the state notifies me one way or the other, I'll either rule on your motion or I will recuse.
Thank you, Judge. That's all my business, Your Honor. May I be excused?
Yes, thank you, Mr. Green.
Thank you.
Your Honor, we do have one more inmate that's with the counselor right now in visitation, going over some paperwork. While we wait for him, we do have two that don't have attorneys assigned, but they are here in the room with us, Mr. McPherson and Mr. Robles.
Okay. We'll go ahead and bring up Mr. McPherson. All right, this is cause number CR-1945, State versus Dylan Kyle McPherson. This is a hearing on a motion to revoke. Mr. McPherson, do you intend to hire an attorney or have you requested court-appointed counsel?
Requested court appointed.
Ms. Abraham, did he complete the paperwork?
Yes, sir. He's the gentleman that I showed you that had submitted to. There was a lot of difference in 10 days. Since that time, he said that he has lost his home and he is going to live with his grandmother. The car that he had on his previous affidavit, he said is in his grandmother's name, not his. And the money he had in the bank, he paid some back utility bills and rent. So I think that was the difference in the two that he had submitted.
With his reporting now, he's filled out a new application and he's sworn to that?
The most recent one, the 1213, the one he just filled out 2 days ago. Yes, sir.
Right. And based on his assertions, if true, would he meet the financial guidelines?
Yes, sir. And I was going to appoint Bill Stevens if that was okay with you.
All right. If he meets the financial guidelines, then go ahead and appoint Mr. Stevens. And we will reset this case then. Let me see when I've got Mr. Stevens coming back.
I think on 2/8.
I think that's right. Let's see, I've got him coming back on 127 for Madkin. And also 2/8. Let's see, 127. 127, that was it. Let's put Mr. McPherson on 127 because he does have a motion to revoke. And Mr. Stevens will be here that day. 127 and 130.
Your Honor, may he be excused?
Yes, ma'am.
Have a seat, sir.
Oscar Robles, CR 16557.
Your Honor.
All right, Mr. Robles. Give me a second. Let me pull up your case and see what we're working with here. All right, Mr. Robles, it looks like it's been about 4 years since you've been here. Are you, this is CR 16557. Are you going to be able to hire an attorney to represent you on your first degree felony engaging in organized criminal activity?
Yes, Your Honor.
You're going to, do you have the financial ability to do that, or is family going to help you hire an attorney?
My family's gonna help me do it.
How long do you think it's going to take before they can help you hire an attorney?
About a week or so.
A week or so. If I reset you to January 4th, do you believe that gives you enough time?
Yes, Your Honor.
Okay. And you've been in contact with them, and that's what they've indicated to you, that they can hire you an attorney?
Yes, Your Honor.
Okay, very well. So what I'm going to do, Mr. Robles, is I'm going to reset you for docket call. Actually, I'm going to set you for status of attorney on January 4th. And that'll be at 1:30, okay? So make sure that whatever attorney they hire, that they get notice of that hearing so they'll know to be here, okay?
Yes, Your Honor.
May he be excused, Your Honor?
Yes, ma'am. Deputy McLeish, do you know if Mr. Ashmore was able to speak with Mr. Runnels today?
He was. Miss Abraham seems to have more information on the outcome of that, so I'm gonna let her fill you in.
Okay.
Mr. Ray?
He's asking you about this.
We're going to trial on January the 10th.
We're going to trial on January the 10th. Very well.
We will be ready on Mr. Kaufman in just a moment.
All right, so Mr. White, we'll go ahead and call Mr. Ragland. Mr. Ragland, if you'll go up to the podium, that podium right there. Just 1 second, let me pull up your case for another day. All right, this is cause number CR 21185, State versus Mitchell Wade Ragland. We were set for docket call on Tuesday, December 14th. Court had Mr. Ragland's name called. He did not appear at 9 a.m. when called. Name was later called loudly, distinctly 3 times in the courthouse. There was no response. The court indicated it was going to issue a judgment nisi alias capias. Mr. White, on behalf of the defendant, requested the court to take that under advisement until today at noon. Court granted Mr. White's request, and then Mr. Ragland appeared approximately at noon today. So the court is going to honor its word and not issue the judgment nisi. And we were set for docket call on Tuesday. What would be your client's announcement?
Your Honor, the state had made us an offer. I've had a chance to discuss that offer today with Mr. Ragland. I'm anticipating we're going to accept that offer. I don't know what the court's docket looks like. I would rather proceed on that sooner than later. If possible. I understand that you like to keep the numbers down to keep everybody safe, so I don't have a problem with that.
Next available docket would be, we could squeeze him on the 6th if you're here on the 6th.
I am.
Sure. All right, we'll set that at 9 a.m. All right, Mr. Ragland, we got one more issue. Show that there is a capias profile warrant out for your arrest right now. Okay, so there's a warrant. We're going to take you into custody unless you can tell me that you can make a payment towards your $1,500 delinquency. Can you make your payment right here, right now?
No, sir.
Okay, so what I'm going to do is I'm going to go ahead and place you in custody on the capias profile warrant. I'm not going to find your bail insufficient. I'm not going to I'm not going to affect your bond at all in this aggravated assault case. So I'm going to go ahead and take you into custody on the capias profile, and we'll have a hearing. Probably have a hearing on the 4th. If you can make a payment, you can make a payment, or you can have someone bring me $250 towards that. Then I will release you.
If I can make a phone call, I can get $250.
When?
I need to make a phone call now.
Okay.
Your Honor, I'll stay around and make that phone call that way.
All right. What I'm going to do is I'm going to order you to stay in the courthouse. You step in the hallway, you make that phone call, and you're ordered not to leave this courthouse until you check back in with me. Sure. All right. I step in the hallway, make that phone call.
I'm sorry, what was the cost?
CR 21185.
Is that from a DWI?
Yeah, it's one of the judge winners, 2019, 18. Yes, ma'am, are you ready?
Mr. Hawkins is here in place of Mr. Harrelson.
Mr. Hawkins for Mr. Harrell. Write that down so I don't call him the wrong name. All right. Good afternoon, Mr. Hawkins. How are you, sir?
I'm fine, Judge.
All right. This is call numbers CR 27-5 and CR 21-351. State of Texas versus Jonathan Lamar Kaufman. And I show that we are, I guess, set for a plea today. Is that right?
Yes, Your Honor.
It looks like Mr. Kaufman is going to be pleading to possession of a controlled substance in penalty group 1, 4 grams to 200 grams, and CR 21-351. He's going to, the state's recommending 12 years confinement, $1,500 fine, restitution, dismiss, 2 cases, fine, $1,500 fine, court cost, 76 days credit towards his sentence. And then state, you are going to be.
Judge, that last part is incorrect. I believe the state had miscalculated the date credit. Mr. Hawkins, can you read what the corrected date credit is?
It reads, can they see?
Just what does that number right there say?
363, Your Honor.
363?
Yeah.
I thought that seemed kind of light.
He's been in our jail alone for almost a year, Judge. So yes. I don't know. I'm not sure exactly where the 76-day number came from, but that new number is correct. I just didn't have it written down exactly what it was.
All right, so 363 days credit. Okay, a big difference there, huh, Mr. Kaufman?
Yes. Yes, sir.
Difference. All right, Mr. Kaufman, do me a favor, sir. Raise your right hand. I'm gonna place you on oath. Mr. Kaufman, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, please put your hand down. Make sure you speak up loudly and clearly for me so I can hear you, and so my court reporter can take down everything you say. Okay?
Yes, sir.
All right, Mr. Kaufman, you are Jonathan Lamar Kaufman, is that right?
Great.
Your Honor.
Your Honor.
And Mr. Kaufman, are you a United States citizen?
Yes, sir, Your Honor.
Do you read, write, and speak English?
Yes, sir, Your Honor. Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir, Your Honor.
Okay. And in this case, you're represented by your attorney, Mr. Lloyd Harrelson Jr. And today, Mr. Hawkins is standing in for Mr. Harrelson. Do you have any objections to Mr. Hawkins standing in for Mr. Harrelson?
I don't, Your Honor.
Okay. And are you pleased with the representation they provided you?
I am, Your Honor.
And do you feel like you've had enough time to discuss your cases with them and have all your legal questions answered?
I have, Your Honor.
And do you understand everything that you have read and signed?
Yes, sir, I do.
And throughout the paperwork, wherever your signature is that your true and correct signature?
Yes, sir, it is, Your Honor.
All right. And Mr. Hawkins, do you believe your client to be competent today?
I do, Your Honor.
And have you explained to him his legal rights, and do you believe that he understands them?
I have, Your Honor, and I do believe he understands, Judge.
All right. Thank you, sir. All right, Mr. Kaufman, the charge of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams is a second-degree felony that does carry a range of punishment of confinement in TDC not less than 2 years or more than 20 years and carries a fine of not more than $10,000. Do you understand that full range of punishment?
I do.
All right. And you've heard me already read what the plea agreement is, which was 12 plus the $1,500 fine. So I would find that that would be a legal sentence within the range of punishment. So, Mr. Kaufman, what I would do at this time is ask you, how do you plead to that charge?
Guilty.
And Mr. Kaufman, are you pleading guilty to that crime because you committed that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right. Court does accept the defendant's plea of guilt at this time. Mr. Hawkins, any objection to the state's evidence?
None, Your Honor.
All right, state's evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, only that the indictment does include 2 enhancement paragraphs. State would abandon both enhancement paragraphs, allow Mr. Kaufman to plead to the charge as the court has admonished him as a second-degree felony of 2 to 20 years in the penitentiary. State would, beyond that, state would have nothing further and would rest and close at this time.
All right. So, Mr. Woodwide, you've indicated that in the indictment, there are 2 enhancement paragraphs.
That is correct, Your Honor.
Okay. And so, Mr. Hawkins, what I will do then is whenever the indictment is returned to me for my signature on the judgments, I will strike through those prior enhancement paragraphs and I'll show those to be withdrawn. Okay.
Thank you, Your Honor.
All right. All right. Is there anything further from the defense, Mr. Hawkins?
Nothing further from defense, Judge.
All right, Mr. Woodwide, see if I have the evidence here. I do have the evidence here. Give me just a brief moment. I'm going to review.
Madam Court.
Yes, sir.
I'm mistaken. The call of the charge. And I had to scratch.
All right. Based on the court's review of the evidence, I do find that there is sufficient evidence to convict Mr. Kaufman of this offense. Court will follow the plea agreement. Court hereby convicts Jonathan Lamar Kaufman of possession of a controlled substance of penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court assesses his sentence pursuant to the plea agreement at 12 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $1,500 fine, $180 restitution, $35 reimbursement fees, $290 court costs. The court will dismiss and take into consideration under section 1245, cause number CR 275, continuous violence against the family, and DA 2020-234, assault of a family or household member with previous conviction. Court awards Mr. Kaufman 363 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Kaufman, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the deputy there to be fingerprinted. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Hawkins, for being here. I appreciate you, sir.
I always enjoy
I'm
coming.
sorry.
Thank you. All right. Sure. Yes, sir.
Does that complete our afternoon docket?
We sure think so.
We are done at the jail, Your Honor.
All right. Tell the jail staff I really appreciate their help today. This was a big docket, and I felt like it went pretty well. So tell them I appreciate that. And had we not had help, we'd probably still be here till after 5. I'm confident.
Amen.
You're absolutely correct. They did an outstanding job for us today.
Tell Sheriff Hendricks I appreciate his assistance and helping us stay on top of these things.
And tell Mr. White, I have something that he owes us a reward.
Mr. White?
Yes.
Well, I'll tell you what, Mr. White's going to step in front of the camera. And he's going to tell you what he thinks about that. What's that?
That's what it is.
Say it again, Ms. Abraham.
Did you leave something at the jail, sir, that you might want?
Well, I don't want it, but
Like your iPad?
He said he doesn't want it. He said he keeps on trying to leave it.
I think
all these good Samaritans just keep turning it back in.
I think he's donating it to Van Zandt County for our law enforcement purposes. That's what we standard do.
Yeah, right. All right. Thank you,
Judge,
Mr.
may Steve be excused?
Half of you may.
Ms. Heisel will be, if she, nope,
She's retained.
I appreciate you, Judge.
All right. Have a good day. We'll see you.
Bye.
All right, we are going to stand in recess until our next docket, 2022.